Hello everyone and welcome to this session on property laws and practice. Today, we'll delve into the fundamentals of property law in India. This is a vital area of civil law touching almost everyone, whether as an owner, landlord, or tenant. A solid grasp of the Transfer of Property Act, 1882, or TPA, and related laws is absolutely essential for legal professionals. Our focus will be on the TPA, which outlines property transfer processes like sale, mortgage, and lease. We'll also touch upon the Specific Relief Act, which provides remedies for breaches, the Registration Act for document validity, and the Indian Contract Act, foundational to all agreements. We'll even briefly mention Tamil Nadu's specific land and revenue laws for local context. Let's begin with an overview of the TPA itself. Its core purpose is to define and amend laws related to property transfers between living persons, creating a clear, systematic, and uniform framework, especially for immovable property. The Act meticulously governs various transfer modes such as sale, mortgage, lease, and gift, detailing the rights and duties of both parties involved. While it primarily applies to transfers between living individuals, its applicability varies. Sections 5 to 37 cover both movable and immovable properties, while provisions from Section 38 onwards, including specific chapters on sale, mortgage, and lease, are exclusively for immovable property. However, the TPA does have its limitations and exceptions. It doesn't apply to transfers by operation of law, like inheritance or court orders, nor is it an exhaustive law for all property transfers in India. Special laws like the SAR-FAESI Act can override its operation. Notably, many of its provisions also don't affect the rules of Muslim law. Structurally, the TPA is divided into 8 chapters, covering everything from preliminaries and general transfers to specific modes like sales, mortgages, leases, exchanges, gifts, and actionable claims. One of the initial challenges in understanding the TPA is the definition of immovable property. The Act's definition is actually negative, stating what it doesn't include: standing timber, growing crops, or grass, primarily because these are intended to be severed from the earth. To get an inclusive understanding, we refer to the General Clauses Act and the Registration Act, which broadly define immovable property to include land, benefits arising from land, and things attached to the earth. Let's break down these key components of immovable property further. Firstly, land refers to the Earth's surface, including everything above or below it, like soil, water bodies, subsoil minerals, and the airspace above. Rights derived from land, such as fishing or mining rights, are considered immovable property. Secondly, benefits to arise out of land, also known as beneficial interests, are intangible rights derived from land. Examples include rights of fishery, ferry, or way, easementary rights, and the right to collect forest produce or even juice from trees. Thirdly, we have things attached to the earth, as defined in Section 3 of the TPA. This includes 3 categories: things permanently embedded in the earth, like houses, buildings, and walls, which are meant for long-term existence; things attached to these embedded structures for their beneficial enjoyment, such as doors and windows; and finally, things rooted in the earth, like fruit-bearing trees or plants that are intended for continued vegetative growth, distinguishing them from standing timber, growing crops, or grass, which are intended to be cut. Now, let's look at some key concepts in the TPA, starting with the transfer of property under Section 5. This is an act where a living person, which can be a natural individual or an artificial entity like a company, conveys property, either now or in the future, to another living person or even to themselves. For a transfer to be valid, it must be an act of the parties, not by operation of law. Both transferor and transferee must be living, though the transferee doesn't need to be competent to contract. The transferor must own the property or be authorized to dispose of it, and the property itself must exist at the time of transfer. Next, Section 6 addresses transferable property. The general rule is that all property, movable or immovable, tangible or intangible, is transferable, unless specifically restricted by law. However, there are several exceptions. You cannot transfer a mere chance of succession, like an heir apparent's hope to inherit, or a bare right of re-entry. An easement cannot be transferred without the property it benefits, and interests restricted for personal enjoyment are also non-transferable. Other non-transferable items include future maintenance rights, a mere right to sue, public office and its salary, military or political pensions, and properties that are inherently untransferable or involve an unlawful object or consideration. Also, transfers to legally disqualified persons, like judges purchasing actionable claims, are not permitted. Moving on to other key concepts, we have conditional transfers, where property transfers depend on a condition being met, either precedent, before the transfer, or subsequent, after the transfer. The Act specifies conditions for their validity, such as absolute restraint on alienation or impossible conditions, which would render the transfer void. Another crucial concept is transferred to unborn persons under Section 13. Property cannot be directly transferred to someone not yet in existence. Instead, an indirect method is used. A prior life interest must first be created in favor of a living person, and the interest transferred to the unborn person must be an absolute interest, not a limited one. This leads us to the rule against perpetuity in Section 14. Its purpose is to prevent property from being tied up indefinitely, ensuring its free circulation and preventing monopolies. The principle states that no interest can be created that vests beyond the lifetime of persons living at the date of transfer, plus the minority period, 18 years, of the ultimate absolute transferee. So, the maximum vesting period is the life of the last prior interest holder, plus any gestation period, plus 18 years. There are, of course, exceptions, such as transfers to public charitable trusts. Now, let's explore some important doctrines in the TPA, starting with the doctrine of election under Section 35. This doctrine is based on the maxim one cannot approbate and reprobate, meaning you can't accept a benefit while rejecting a burden from the same instrument. If a transferor gives a benefit to a person while simultaneously attempting to transfer that person's property to someone else, the true owner must elect to either confirm the transfer and receive the benefit, or dissent from the transfer, relinquish the benefit, and potentially compensate the disappointed transferee. This doctrine is universal, applying to all property types and across religions. Another vital equitable principle is the doctrine of part performance in Section 53A. This protects a transferee who has taken possession of an immovable property under an unregistered contract for sale, provided certain conditions are met. It acts as a defense to protect their possession, not to confer ownership. Key conditions include a written, signed contract with ascertainable terms, the transferee taking or continuing possession in part performance, performing or being willing to perform their part of the contract, and having done some act in furtherance of it. Continuing with important doctrines, we have lease pendens, meaning a pending suit. Under Section 52, this principle states that during the pendency of a suit involving rights to immovable property, no party can transfer or deal with the property in a way that affects the rights of other parties under any future court decree. Such a transfer, while not void, will be bound by the court's decision. This pendency begins when the suit is instituted and continues until the final decree is satisfied or its execution period expires. Then there's the doctrine of ostensible owner in Section 41. An ostensible owner is someone who, with the real owner's consent, appears to be the owner of immovable property, like a, quote, benemadar. If such an ostensible owner transfers property for consideration, the transfer is valid if the transferee acted with reasonable care and good faith in ascertaining the transferor's authority. This doctrine protects bona fide purchasers, but it does not apply to gratuitous transfers or situations where both parties know the true facts. Finally, the doctrine of feeding the grant by estoppel, found in Section 43. Also known as estoppel by deed, this principle is an exception to the rule that no one can transfer a better title than they possess. If a person erroneously or fraudulently represents that they are authorized to transfer property and does so for consideration, and later acquires an interest in that property, then, at the option of the transferee, the transfer will operate on that subsequently acquired interest. The transferor is thus estopped from denying their original representation, validating the previously defective transfer. Let's now look at two primary modes of transfer: sale and mortgage. Sale, under Section 54, is the transfer of immovable property ownership in exchange for a price. For tangible property valued at 100 rupees or more, or for intangible property, a sale must be by registered instrument, a sale deed. For tangible property less than 100 rupees, it can be by registered instrument or by delivery of possession. It's crucial to distinguish this from a contract for sale, which is merely an agreement to transfer in the future. It doesn't create any immediate interest in the property itself. Mortgage, defined in Section 58, is the transfer of an interest in specific, immovable property to secure the repayment of a loan or debt. The mortgagor is the one transferring the interest, and the mortgagee is the one receiving it. The money secured is the mortgage money, and the instrument affecting the transfer is the mortgage deed. The TPA outlines various types of mortgages under Section 58. A simple mortgage involves no possession delivery, but the mortgagor promises to pay and allows the mortgagee to sell the property upon default. A mortgage by conditional sale involves an ostensible sale that becomes absolute on default or void upon payment. In a usufructuary mortgage, the mortgagor delivers possession, allowing the mortgagee to receive rents or profits in lieu of interest or principal. An English mortgage involves the mortgagor absolutely transferring the property to the mortgagee, with a proviso for retransfer upon repayment. A mortgage by deposit of title deeds, or equitable mortgage, occurs when the mortgagor delivers property documents to a creditor with intent to create security, requiring no registration. Any mortgage not falling into these 5 categories is an anomalous mortgage. Moving on to lease and gift. A lease, under Section 105, is the transfer of a right to enjoy immovable property for a certain time, or in perpetuity, in exchange for a premium or periodic rent. The lessor is the owner granting the right, and the lessee is the one receiving it. Regarding revocation of gifts, under Section 126, a gift can only be revoked if that right is expressly reserved in the gift deed, contingent on a specific event, not dependent on the donor's mere will. Once completed, a gift is generally irrevocable. Importantly, Chapter 7 of the TPA, which deals with gifts, does not apply to gifts under Muslim law, hiba, or to deathbed gifts, donatio mortis causa, as these are governed by their respective personal laws or the Indian Succession Act. Gift, as defined in Section 122, is a voluntary, gratuitous transfer of existing movable or immovable property from a donor to a donee, accepted by or on behalf of the donee. Key elements include the property being in existence, the transfer being voluntary and without consideration, and the donor being competent. Crucially, the donee must accept the gift during the donor's lifetime and while the donor is still capable of giving. The mode of gift depends on the property. Immovable property requires a registered and attested instrument, while movable property can be transferred by registered instrument or simply by delivery of possession. Let's look at the duration and termination of leases. Section 106 states that in the absence of a contract, leases for agricultural or manufacturing purposes are deemed year to year and terminable by 6 months' notice. For all other purposes, they are month-to-month leases, terminable by 15 days' notice. Termination, or determination of lease, can occur in several ways, as outlined in Section 111. By efflux of time, the happening of a specific event, merger of interests, express or implied surrender, forfeiture due to a breach or insolvency, or upon expiry of a valid notice. Finally, holding over under Section 116 allows for a deemed renewal if the lessee continues possession after termination and the lessor accepts rent or assents. We also have actionable claims, defined in Section 3 as a claim to any unsecured money debt or a beneficial interest in movable property not in the claimant's possession, for which relief can be sought in civil courts. Examples include arrears of salary or rights under a contract, but they exclude secured debts or decrees for rent arrears. It's crucial to understand the importance of interconnected laws. The TPA is not a standalone piece of legislation. It's intricately linked with other crucial laws. It's often considered an extension of the Indian Contract Act. Its provisions are frequently supplemented by laws like the Indian Registration Act for mandatory document registration, the Specific Relief Act for remedies, the Limitation Act for filing periods, and the Code of Civil Procedure for procedural aspects of property suits. Understanding these interconnected laws is vital for any legal professional dealing with property issues. Finally, let's briefly touch upon the transfer of actionable claims under Section 130. Such transfers must be effected by a written instrument, signed by the transferor. Once executed, the transfer is complete, conferring all rights upon the transferee, even without immediate notice to the debtor. However, proper written notice to the debtor is necessary to bind them. The transferee takes the claim subject to all liabilities and equities the original transferor was subject to. Notably, judges and legal practitioners are disqualified from purchasing or dealing in actionable claims. Lastly, Chapter 8, dealing with actionable claims, does not apply to stocks, shares, debentures, or negotiable instruments. Thank you for your attention. Hello everyone.